Recently, the Supreme Court denied review to both rifle and magazine ban cases, but now one of the cases where they had prior GVR'd and said that they would be watching it closely, it has now jumped up in importance. That's because the Third Circuit en banc panel just took review of this case, snatched it from the lower court, and said they're going to rule on this on their own. And now the state of New Jersey is doing everything in their power to try to avoid that and get the court here to uphold this ban. So let's break down what is happening in this critical case. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can double check to make sure YouTube is not to unsubscribe you, and check out my website, armscholar.com. Over there, we have a lot for you guys, including a free legal guide that you can sign up for. All you have to do is put in your email, and we email you over a free PDF. Now, as I mentioned in the intro, in this video, I'm going to be discussing two critical cases which challenge a state's ban on rifles and magazines. This magazine ban was recently granted, vacated, and remanded back down to the lower court for a new decision in light of what the Supreme Court said in their 6-3 ruling in Bruin. Well, that district court recently issued a decision in two consolidated cases called ANJRPC versus Platkin and also Cheeseman versus Platkin. And in that ruling, the court came to one of the more perplexing Second Amendment analysis that I've seen in a long time. Essentially, they found that the state's ban on Colt AR-15s is unconstitutional and that it must be struck down. However, they avoided looking at any other rifles or semi-automatic centerfire rifles, which were banned under that law. And at the same time, they found that these magazine bans could be upheld because although these magazines were determined to be arms, they still believed that they were dangerous and unusual, and that it would be in the public's best interest to restrict the access to those magazines. That horrible ruling has now been appealed to the Third Circuit Court of Appeals, and it was recently argued in front of a 3-judge panel on July 1st. However, like I mentioned, recently we got a very surprising update. The Third Circuit en banc panel on their own decided to take review of this case, took it from the 3-judge panel, and they're going to rule on it on their own. Now, in response to that en banc panel move, the state of New Jersey has just submitted a supplemental notice arguing that the court here should follow what other courts have done recently, like the Second Circuit, who upheld these type of rifles and magazine bans that have been put in place in other states. This is a very interesting update, very interesting case, and so let's break down what is currently happening. Now, this case involves the state of New Jersey's ban on so-called assault weapons and their magazine restrictions as well. When it comes to the magazine ban back in 2018, New Jersey passed Assembly Bill 2761, banning possession of firearm magazines that have a capacity to accept more than 10 rounds. This case initially was reviewed and made its way to the Supreme Court back in 2022, but later it was remanded back down to the lower court for a new ruling and a new decision in light of what the Supreme Court said in Bruin. The district court then, when they got the case back in their hands after Bruin, actually consolidated this case, the ANJRPC case, along with the Cheeseman case, which dealt with the state's rifle ban. The court then reviewed those two cases and issued a new decision, and like I said, it was a horrible hodgepodge decision that really showed that the lower court did not want to follow what the Supreme Court said in Bruin. In that ruling, the judge struck down only one part of the rifle ban, essentially just dealing with Colt AR-15s, and essentially avoided ruling on any of the other firearms that are restricted under that law. He then also upheld the magazine ban despite the fact that he also found expressly and held that magazines are protected arms. But now this horrible ruling is being appealed to the Third Circuit Court of Appeals, and there was originally arguments held in front of a 3-judge panel on July 1st, and the 3-judge panel was set to rule on this case. However, all of that has now changed. Before the 3-judge panel could actually rule on this case, the en banc panel in the Third Circuit on their own, so sua sponte, which means simply just on their own issue, on their own order, they decided to take review of this case. Now, the current makeup of this en banc panel is 7 Republican appointees and then 6 Democrat appointees. Judge Smith is a senior judge who actually elected to participate as a member of the en banc panel court, which really swayed the lean towards Republican appointees, which is very good. And that's interesting also because Judge Smith has recently been pro-2A and has been involved in these decisions that are pro-2A. Recently, he issued and was joined in a decision on the 18 to 21-year-old Pennsylvania concealed carry win that we got in January. And then also keep in mind the Third Circuit en banc panel recently issued the pro-2A Range versus Garland case decision. In that case, they found that Brian Range should not be prohibited for life from having guns simply because he lied on a food stamp form essentially 20 plus years ago. And it appears that the state of New Jersey kind of senses some trouble with this case. Recently, they submitted a supplemental brief to the en banc panel, arguing that they should follow how the Second Circuit recently ruled in regards to a different rifle and magazine ban case. The supplemental notice of the state of New Jersey states that the state writes regarding NAGR versus Lamont, which rejects a Second Amendment challenge to restrictions on assault weapons and LCMs. 5 circuit courts have now unanimously rejected such challenges. The panel initially addressed the scope of the litigation. Judge Walker's opinion, joined by Chief Judge Livingston and Judge Nathan, found that the challengers' facial challenge to the assault weapon law could not proceed because the challengers offered no arguments or evidence in opposition to many of the challenged statute's other applications. The panel thus focused, as relevant here, on AR-15 style rifles and LCMs. The panel next rejected the challengers' argument that assault weapons and LCMs merit unavoidable protection if they are widely popular. The panel explained that this approach distorts both precedent and history and would hinge the right on a trivial counting exercise with absurd results where unusually dangerous arms become protected merely because they become popular before the government can sufficiently regulate those items. And this would strain both logic and administratability. Instead, even assuming these items are protected, the panel joined every circuit court to address the question in recognizing a historical tradition of regulating unusually dangerous weapons, not just before they are circulated, but especially after their use in terror or to perpetuate mass casualties. They state that, and the panel joined the same circuit consensuses in finding that assault weapons and LCMs and these restrictions fall within the tradition, recognizing that they are regulated, unusually dangerous weapons and have grave capacity for inflicting harm disproportionate to self-defense rights. This court should reach the same conclusion as its 5 sister courts. They state that New Jersey's assault weapons and LCM restrictions are constitutional. So New Jersey is now scrambling to support their state bans in light of the en banc panel taking this case on their own. This will now be argued in front of the en banc panel, and it's set for oral arguments on October 15th. So really soon, in just a month, this is going to go to the en banc panel. We're going to be watching this closely to see, how does this play out during the oral arguments, what type of questions are asked, and what is the general tone of the Third Circuit en banc panel. The Third Circuit has issued some pro 2A decisions lately, so this would be an interesting one to also see develop out of the Third Circuit, and especially with the lean right now of 7 Republican appointees and 6 Democratic appointees, and even one of those Democratic appointees ruled in favor of the range case. So it's going to be interesting to see how this plays out. But regardless, this is good because now this AGRPC and Cheeseman case dealing with rifle bans and magazine bans is one step closer, to the Supreme Court. It's on the final merits. It deals with rifles and magazine bans. And the Supreme Court had GVR'd the magazine ban case before after Bruin. And also, this is one of the cases that the Supreme Court stated expressly that they're going to be watching, especially, when Kavanaugh issued the denial notice in the Snope case, and he said that, they would address these rifle bans and magazine bans in a term or two. This is one of those cases that they said they would be watching. So this is a very important appeal, very important oral arguments that are now coming up, and it's interesting now to see that New Jersey is scrambling to try to say that the Third Circuit en banc panel should just reject this, uphold these bans based on what other circuit courts have already said. So as we get more information, as this develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to like, comment, and subscribe. Also, you can check out my website, armscholar.com. Like I mentioned over there, we have a lot for you guys that you can check out. And we also have the free legal guide that you can get over there. All you have to do is put in your email, and we email you over that PDF. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.